A very warm welcome to lesson number 15 in our 50-part series on the law of evidence. In lesson number 13 and 14, we had a look at part 1 and part 2 respectively. In today's lesson, we will see part 3 of the Indian Evidence Act. I will not get into the details of the provisions in today's lesson because this is meant to be a summary. But by the end of this lesson, you would be acquainted with the 5 chapters from chapter number 7 to chapter number 11, as well as the sections extending from section 101 to 167 in this chapter. So let us get into the chapter, and by the end of this lesson, these 15 lessons, you should be in a good position to be able to read and understand the law and evidence by your own self. We've already seen the general scheme of the Act in lesson number 12, that there are 3 parts, 11 chapters and 167 sections. We've also discussed part 1 and part 2 in some detail in lesson number 13 and 14. In today's lesson, we will learn something about part 3, which deals with the production and the effect of evidence. Part 3 of the Act contains 5 chapters from chapter number 7 to chapter number 11. We will now study each one of these chapters in some detail. With our first chapter in this. So we begin with our first chapter in this part, chapter number 7. It is titled Burden of Proof. Now, what is burden of proof? Very simple. Let us say there's a certain fact, alright? Now, when you're talking of evidence, then basically either this fact has to be shown to exist or not to exist, right? Either the fact exists or you want the court to believe that the fact does not exist. Simple. Now, one person is bound to show this, right? The burden lies on one person. So that is the burden of proof, right? The person who is bound to show or to prove the existence or the non-existence of the fact is said to have the burden of proof. Like for example, when we say the burden of proof in a criminal trial lies on the prosecution, right? You must have heard this term. What does that mean? What that means is that the prosecution is bound, right? The prosecution is bound to prove the fact. Which fact? The fact that the accused is guilty. So the burden of proof lies on the person who is bound, right? That's what the burden of proof is. And of course, you can think of it like this. And so you find this in section 101. Section 102 goes on to explain this a little bit more. Let us take, for example, you have your trial. On the one side, you have the public prosecutor, and on the other, you have the accused, right? And in between, you have the judge. Let us say both of these parties were to keep quiet. So this person keeps quiet, and this person keeps quiet. What is the result? Is it a stalemate? Is it a draw? No. If both the parties keep quiet, there is a winner. Who is the winner? The winner is the accused. So you can think of it like this. If both parties were to keep quiet, then one person wins and the other person loses. So you can say that the burden of proof lies on the person who would lose if both the parties kept quiet. So you've understood the concept of burden of proof. Now let me just give you a couple of examples, maybe 1 or 2, of the kinds of sections that you can expect from section 101 to 114A. It basically talks of the burden of proof in certain special circumstances, so some certain specific circumstances. Let me give you an example. Let us say we know that if a person commits an act whereby this person is killed, right? Now, this person by definition may be guilty of murder, right? Let us say he killed him with a knife or whatever. Now, suppose I were to tell you that this person is 2 years old, or if I were to tell you that he's of unsound mind, or that he did it in an act of private defense, then a general exception applies, right? So now, what is the rule relating to general exceptions? Is the burden of proof on him to say that actually I am of unsound mind or that I was acting in private defense, or is the burden of proof on the prosecution, right? So we know that ordinarily the burden of proof lies on the prosecution in a criminal trial. However, when it comes to the specific point of whether a general exception is applicable or not, then that lies on the accused, right? Now, how do you know that? Because there's a section in between this, which is called section 105, which says that the burden of proof of the existence of a general exception lies on the accused. So you have some provisions like this. Let me give you one more example. That example is of a section that I find perhaps one of the most interesting in the whole of the Evidence Act. That section is section 114, right? Section 114 contains some presumptions, right? And I want you to understand that presumptions are always coterminous and coexistent with burden of proof. Let's think of it like this. When you have on the one hand the prosecution and on the other hand the accused, so you have the accused and the prosecution. We said that the burden of proof lies on the prosecution. Do you realize that along with the burden of proof always exists simultaneously a presumption in the favor of the other party? So you see there's a presumption of innocence. So you must understand that whenever there's a burden of proof, there's always a presumption, right? So you will find that in this chapter, which is otherwise titled Burden of Proof, some sections will talk about burden of proof and some sections talk about presumptions. That's why I'm giving you this example. Now, section 114 broadly says that the court may presume certain things, right? So it goes on to give you some illustrations therein. You can have a look at this provision if you want to, right? It goes on to give you some illustrations. For example, it says that if there is an accomplice, we may consider the accomplice's testimony as being unworthy of credit, okay? Likewise, let us say there's somebody who refuses to depose. Let us say that somebody is asked a question, an accused is asked a question, and he refuses to talk. Now, you can't force him to talk because you know that there's a right against forced confessions. But the court can draw presumption that he's keeping quiet because he thinks that if he speaks, it will be detrimental to him, it will be bad for him, which is known as an adverse presumption. So what you do is that we draw an adverse presumption when somebody keeps quiet, when an accused keeps quiet, right? So you have some of these presumptions here, which means that there's also a burden of proof lying on the accused to speak, because if he doesn't speak, he has an adverse presumption. So you must understand that burden of proof and presumptions always exist as pairs, they coexist. Where there's a burden of proof, there will be a presumption somewhere, right? That's why chapter number 7 deals with presumptions and burden of proof. You can go ahead and see them. For example, if you look at section 112, it deals with the presumption of paternity. You can go and have a look at some of these. You will get an idea of what is there in this part, in this chapter. Let's go ahead and look at the next chapter. Chapter number 8 is fairly simple and short. It deals with this principle called estoppel, right? So sections 115 to 117, just 3 sections that discuss the principle of estoppel. 2 points that I want to tell you. First, that estoppel operates only in civil matters, right? What is estoppel? Estoppel is basically a principle of evidence whereby a person is not permitted to make a statement and then detract from it. So you can't say something, make a representation, and then tomorrow deny what you said. So if you say that, for example, that you're the owner of this house and therefore you sell the house to somebody, then tomorrow once you've sold the house, you can't say that no, I don't own this house or I don't own this land. So the court acts as if you were actually speaking the truth, right? So you can't go away and you can't shun your responsibility by saying something today and then revoking that tomorrow. In other words, you cannot blow hot and then blow cold. That is the principle of estoppel. There are a couple of types of estoppel. There is issue estoppel, right? There is promissory estoppel. There is estoppel by conduct. You can have a look at the provisions. You will get a couple of ideas of what is given regarding estoppel in the Evidence Act. You can also search for this on Google and you'll get a couple of points about the various kinds of estoppel, estoppel in pace. You can see all of these things and you'll get an idea, but you get the point. Chapter 8 deals with the principle of estoppel which is applicable only in civil matters. Let us proceed. Now, chapter number 9 is interesting. It talks about witnesses. It tells you as to who a competent witness is. So a witness is basically competent if he is someone who is capable of understanding the questions that have been put to him. So let us say there's a child of the age of 5 years. Is he a competent witness? Yes, he can be competent if he is able to understand the nature of the questions put to him, right? So even a 2-year-old in that sense could be competent. So competence is basically whether a person is capable of understanding the questions that have been put to him. Thereafter, we have other situations in which people cannot be witnesses. For example, let us say you have a husband and wife. Now, of course, one might be a witness to another person and say something about someone else, but the court realizes that there's a certain relationship between a husband and wife, a relationship of privilege, a relationship of confidentiality, of confidence, of trust. Therefore, the court says that in several circumstances, I'm not getting into the details of it, in several situations, the court will not let a spouse come and depose about the other spouse. Why? Because it is believed that the matrimonial tie should be respected, honored, and therefore the court does not want to get into what was communicated in active confidence and trust while there was a marriage, right? Similarly, there might be some things which have been said to a lawyer by his client. This is also protected, right? So what has been made in active confidence by a client to his lawyer, that is not something that the lawyer can now come and declare to the court, right? So there are some restrictions on that. This is again something that you find in this chapter. You find some more provisions about what is the number of witnesses needed. For example, section 134 tells you that to prove a certain fact, there is no required number of witnesses needed. It could be even one, which means that it gives you a very basic principle of evidence. Section 134. It tells you that evidence is weighed and not counted. So you have a rough idea of what is contained in chapter 9 as well. It contains some provisions relating to witnesses, about the concept of privileged communication. It talks about certain specific people, like for example, section 133 talks in particular about the testimony of an accomplice, right? So it says that an accomplice is a competent witness. So you have an idea of what you have in the 120s and the 130s. So we're kind of acquainted with this chapter. Let's go ahead. Now we foray into chapter number 10. Chapter number 10 deals with the examination of witnesses, right? Let me give you a few examples of what you can find in this. Now, what is the order in which the witnesses should come? Well, 135 talks about that, the order in which they should come. 136 tells you that the judge decides the admissibility of the evidence. So let us say a witness comes and says something. Who is the person who decides whether what he is saying is admissible or not? It is the judge, right? Then you know about the examination of witnesses, that there is something called an examination in chief. Then there is what is known as the cross-examination. And then there is this thing known as re-examination, right? What are these things? Given in 137. Examination in chief is when, let us say, you have two parties, right? You have two parties here, and they have their lawyers. Of course, let's say you have his lawyer here and he has his lawyer here. Now, when a question is put by a lawyer to his client, right? That means when there's an examination of a witness by his own lawyer, this is called the examination in chief. However, when there is an examination of a witness by the other side's lawyer, let's say if he's asked here, this is a cross-examination, right? And then a re-examination follows after cross-examination, right? So again, in this case, it is by the party who called him. So examination in chief and re-examination are done by the lawyer to his own client, which means the witness by his own lawyer, right? That's examination in chief and re-examination. However, cross-examination, as the name suggests, is between the witness and the adverse lawyer and the adverse counsel. So you understand as to what these are. This is given to you in 137. Okay, let's move ahead. When we talk about the examination of witnesses, there are some things that can be asked and some things that cannot be asked. For example, you may have heard of this thing called a leading question, right? Sometimes the questions tend to give the answer, and no matter how you respond to them, you find that you are getting stuck in a trap. So there are some situations in which leading questions can be asked and some questions in which leading questions cannot be asked. So you see some provisions relating to leading questions in this chapter. Also, you find a couple of provisions relating to the nature and the decency and the quality of the questions asked. Now, can you ask something related to the character of a person, right? Can you make, in the cross-examination, can you ask something which tends to lower the estimation of the character of a person in the eyes of the court? Can you do that? There are some situations in which you can, some situations in which you cannot. 146, for example, talks about that. Similarly, can the manner in which you speak be impolite, indecent, scandalous? Well, look at section 151 and 152. They tell you that a certain kind of propriety, a certain kind of decency requires to be maintained. You cannot ask questions that are intended at annoying a person, annoying the witness. So again, these are provisions related to the examination of witnesses. Another thing that I'd like to discuss is perhaps this thing that you've heard, this term called hostile witness. So what happens is sometimes one's own witness may not be acting in the manner expected of him, perhaps. And in such a situation, it might be required to put such questions that are otherwise ordinarily asked in cross-examination, which means you might sometimes want to cross-examine your own witness, right? So there are provisions relating to that. You might also want to show that this witness is no longer worthy of credit, right? So you have sections 154 and 155 dealing with that. You will not find the word hostile witness in these, but it kind of deals with this subject as well, right? Let me discuss a few more provisions. For example, now let us say you're examining a witness and he doesn't recollect, because now you see he may have seen something and now he comes as a witness weeks, months, or even years later. So sometimes you might have to refresh his memory, right? So you have some provisions relating to the refreshing of memory, section 159 to 161, right? And then perhaps we'll deal with one more section, which is section 165, right? So during the examination of witnesses, we've seen that questions can be asked in the examination, the cross-examination, and the re-examination by the two parties, by the two counsels of the parties. But there's also one very important thing that is called a court question, right? Which means that the court, the judge, can also put questions to the witnesses, and section 165 deals with that. So I hope by now you have an idea of what is contained in chapters in the first 4 chapters, leaving us with only one chapter to see, which is chapter number 11. It's a short chapter. Let's just have a look at it. Finally, chapter number 11, short and sweet. In fact, the shortest. Only one section in this chapter. Now, what we've seen in the entire Evidence Act is that it serves a certain purpose. What is the purpose of the Indian Evidence Act? It is that there should be a proper admission of evidence, or there should be a proper rejection of evidence, right? Which means that if there's an admission of evidence, it should have happened in accordance with the procedure. If there's a rejection, it should happen in accordance with the procedure, right? Now, what happens in case it is improper instead of being proper? So as you can see, it deals with the improper admission and rejection of evidence? Well, it tells you this very basic principle of law, which is that substantive justice must be given precedence over procedural requirements. So the substantive law is more important than procedural law. So the effect of section 167 basically is that, let us say the procedure has not been duly followed, which means there has been an improper admission or rejection of evidence. Okay, that is wrong. But let us say it does not affect the final outcome, which means that, let us say if it had been done improperly or properly, the outcome would have been the same, but you happen to have done it improperly. So if the outcome is the same, which means there has been delivery of substantive justice, in that case we can ignore this improper admission or rejection of evidence, which basically means that simply an improper admission or rejection of evidence does not vitiate the trial. There is no need for a new trial simply because some procedure has not been followed. But that is only if substantive justice has been delivered. If there has been substantive justice, if the ends of justice have been met, then minor procedural aberrations can be condoned and ignored. So that gives you an idea of what is contained in part 3 completely. So in the last 4 videos, we have seen a summary of the whole law of evidence, basically the Indian Evidence Act, and this puts you in a position to now go ahead and read by your own self. So I hope now that by the end of this lesson, you are fairly acquainted with the entire scheme of the Act. I hope this lesson was of use to you. Thank you for your patience. Good day.